Viewers, welcome to the Carbone Lawyers podcast series, better known as the Law Lab. My name's Tony Carbone. I'm the managing partner of Carbone Lawyers. With me today, I've got John Carancis, a credit specialist and the head of personal injuries at Carbone Lawyers. Good day, John.
Hi, Tony. Hi, viewers.
And we have a senior associate that runs the Essendon branch of Carbone Lawyers, Nadine Hanna. Good day, Nadine.
Hi, Tony. Hi, viewers.
Viewers, we've got a very interesting subject on WorkCover today. We're going to discuss some WorkCover cases just to highlight some very important facts. But before that, we're going to do a couple of stories of what's been in the news lately.
Yes.
And John, the real big story is this case coming out of the US where the jury has come back and found the police officer involved in George Floyd's death as guilty.
Yes, guilty. Derek Chauvin, Tony, a jury of 12 peers in America. Tony found him guilty of 3 charges, 2 charges of second and third degree murder and manslaughter, Tony. It's a guilty verdict, and we've all seen the footage, Tony. It's a pretty disgusting behaviour, isn't it, Tony?
Yeah, look, it's pretty sad. Nadine, you know what I find in some ways astounding about what's happened? The civil case in this matter settled before the criminal verdict came out.
Yes, for an astronomical amount, I've heard.
It was close to 30 million. But I guess maybe you can explain to the viewers there's a big difference between the two tests, isn't there?
Of course.
Yeah.
So the civil test is on the balance of probabilities. So it's more likely than not, or we usually say to our clients...
We say 51%.
51% will be what wins your case, whereas the criminal standard of proof is beyond reasonable doubt. So there cannot be a glimmer of doubt in when you are deciding or deliberating on whether or not a person is guilty of the crime.
I think in this case, Tony, 10 minutes of footage of a knee on someone's neck was pretty convincing.
I think the police officer that was charged was really up against it when his own commander-in-chief
Yes.
got in the box and said he did everything wrong.
Yes.
You know, he's trying to argue, his defence was that, or one of his defences was that he just followed police standing orders.
He just acted rogue, didn't he, Tony?
Well, that's how the evidence came out in the end.
That's how the evidence came out, and also I think part of the defence, Tony, was that he didn't necessarily die from the lack of oxygen from your knee, from a knee being on someone's neck. He might have also died from his heart issues and also the exhaust from cars driving past, breathing that in.
There was a lot of
scientific
evidence around the size of his heart, if it was too big or too small.
Fortunately, the jury saw this for what it was. It's plain murder, Tony. Simple as that.
I'll tell you what I found surprising. The chief of police coming out and giving the damning evidence he gave.
It's totally unacceptable behaviour, Tony.
Yeah.
Totally
Oh,
unacceptable.
no, I'm not for 1 minute condoning what happened.
No.
I guess on the back of what happened last week where that police officer shot that young man, it made his chance of probably getting off this a lot harder, don't you think, John?
Well, yeah. I mean, each case is separate, and it looks like she may have made a mistake, thinking it was a taser gun.
Are they similar sort of objects? I'm not sure.
Yeah.
They are?
Yeah, in America, yes, they are.
So there will be this, I think this George Floyd case is going to open up some serious floodgates in the American system because it's one of the first criminal cases where a white police officer has been
guilty.
Look, any which way we go,
interesting to see.
it's a very sad state of affairs all round.
Totally sad.
Absolutely.
You know, and it's tragic that, you know, there's this raging debate about white and black and all this business because really, after all, you know, in the year 2021, we shouldn't still be where we're at.
We're all humans.
You know, for crying out loud, we all need to treat each other equally. All right, let's get on to this other case. There's some serious allegations overall at the state of Victoria and the council involved in this case, John, involving the slug that put the company out of business. Tell us a bit more about this.
Yeah, Tony, it's an interesting case. It's been going on for a couple of years now. It's a company that iCook provided a Meals on Wheels type of situation for elderly homes, people
And
hospitals.
Yep.
And during an inspection by a health inspector, a council health inspector, a slug was allegedly found, Tony, on the floor, and that led to the place being closed down. That led to Brett Sutton naming the facility in public. Tony, the damage to this, the reputation of this company, it's now claimed in court proceedings in the Supreme Court of Victoria. So loss of quite a few people's jobs, and a $25 million business has gone down the drain.
Yeah, they say it was worth over around $50 million. But Nadine, you know what's really astounding? There's some serious allegations levelled at the state of Victoria and also the council involved because they say the competing business providing Meals on Wheels was also funded by the state and council.
Yeah. So the ramifications for all now, we're waiting to see what will actually really happen with these proceedings.
It's pretty serious when you think about it, isn't it, John?
Yeah, the allegation being that the slugging question was planted.
Yeah.
That'll be interesting to see how that plays out in court.
Oh, yeah, I'd love to see what the evidence is.
And if there's video evidence of that.
And the other thing they found was that they said that apparently the thing that blew this up was a lady was allegedly contracted listeria, which is a nasty condition from
food poisoning.
And they say, but she died of a heart condition.
So is the listeria a red herring, or are they using the heart condition?
Well,
as
they
a
were
red
trying to
herring?
say
Are they
that she
trying to link it all?
contracted the listeria perhaps from
the
business being, dirty. I don't know. But as it transpires, it had nothing to do with
And when
food.
these type of allegations become public, Tony, the company literally was closed down overnight.
Oh, yeah. It was diabolical, really.
And
It's been around for a long time, this company. It's very, very tragic.
A lot of people lost their jobs.
Of course.
And so reputations are at stake now.
And, a business that's been around nearly 50 years, that's a long time. All right, viewers, we're going to discuss WorkCover. Now, just to put in perspective, there's at least 60,000 WorkCover cases of varying degrees of severity in Victoria every year.
Exactly.
And John and Nadine, who see a lot of the serious ones, would tell you that about 5,000 get proper damages. Now, one of the important cases that we're going to discuss, viewers, is a matter of Ryan and Victorian WorkCover Authority. It's a 2020 decision, John.
Yes.
It's very important because it highlights a lot of the people we represent and a lot of the people injured in the WorkCover system. Tell us the facts, John.
Yeah, thanks, Tony. It's a county court decision in Victoria. It's regarding a worker who is required to place GPS units into the canopy of a truck. A lot of twisting, turning is involved and stretching, and whilst he's performing this work, he does his knee, Tony.
Well, John...
And he aggravates his knee in one sense because he's got pre-existing knee issues.
Yep. I'll get on to that. Nadine, one of the key components of his allegations are that he was positioned on a seat to hold the dashboard in place in an awkward and uncomfortable position. We see that a lot, don't we?
Absolutely.
Yeah. And that's one of the biggest complaints by a lot of workers.
Absolutely, because it's all about the manual handling first and foremost. Yes. And also just the positions that, and part of the manual handling is a position
well, just on that issue there,
to adopt.
We've got the Occupational Health and Safety Act and regulations, correct?
Yes, that's right.
It places some pretty onerous obligations on employers.
That's right. So anything that resembles manual handling of repetitive nature or strenuous nature, not even strenuous, Tony, it sparks the OH&S regulations that will impose on the employer to perform risk assessments or turn their mind to the duties that the employee has to perform.
Well, in fact, they're obligated to do a risk assessment. Exactly. What is it, John? What's a risk assessment?
Risk assessment is literally the employer, via their OH&S official, going through what is required in this physical activity and to find out whether or not there's any risk of injury to the worker.
So it's really to assess the type of work you're doing and if there's any unnecessary risk.
Exactly.
And to eliminate hazards that could cause damage.
Absolutely.
Which could cause a physical injury. And in this case, Tony, there's no suggestion that there was a risk assessment.
Just on that issue, John, quite frankly and realistically, a lot of the cases we've done, when you've done discovery, during the court process, how often have you seen a risk assessment?
Not often at all.
Not often at all. I don't even know if the employers understand what it means.
That's right. Or even if the risk assessments are sometimes present, they could be outdated or not turning to the specific duties that an employee would actually be performing.
This particular case, Nadine, there was a complicated history of knee injuries.
That's right. So there was quite substantial history of pre-existing condition with this client, or with this plaintiff, I should say, and he had some number of surgeries on the right knee. It was relatively asymptomatic until up to the date of injury, wasn't he, Tony?
Yeah, I'm not sure about being asymptomatic because he had so many surgeries and problems with these knees, especially the one that he injured in this case, that I don't think his evidence would have been, I'm totally symptom-free. But he was functioning...
There was a period
he
of
was
time
functioning
he
well.
was fine.
Yeah,
He was
In the end, Tony, he was working unrestricted duties.
Yes. Well, look, this case here, John and Nadine, really highlights the importance of being able to piece together the history, correct?
It's very important, Tony. In this case in particular, he's got surgery that's occurred repeatedly to his right knee. Now, that has to be disclosed, and there was a criticism in this case whereby a lot of the treaters didn't realise the full extent of his history. And that really needs to be pieced out and disclosed when we're getting medical reports from doctors.
And also, you almost have to forensically look at the scans, the past scans and the current one, to see if there's a difference between the two. Because a lot of the times the defendants argue that the condition a person's now got is just a continuation of the old injury, correct?
That's right, or comparative radiology. But more often than not, we really rely on what the worker is saying about his before and after together with the radiology itself.
But there's nothing wrong in the end with the worker saying, yes, I had these problems. However, I had recovered sufficiently to
do full-time work.
Full-time work, exactly.
And occasional symptoms here and there.
Exactly.
John,
Yes.
the reality is, and I don't care what anyone says, and I give these talks on a regular basis to medical practitioners, other service providers, most of our WorkCover clients are not pristine.
No, it's always an aggravation.
More often than not, Nadine?
Absolutely. I mean, we're not in the 20-year-old bodies that we once were, sadly. So we are aging, and we do have these conditions, especially those clients that are in manual physical work.
Although
he's still the deterioration that we see.
He's still got quite a good sum of money on this.
I'll go to that. I'm going to go kaboom with that one in a minute. But the thing is, what I find really, what people need to know, and this is important, John, these cases are very complicated, right? They need legal advice.
Absolutely.
They need to piece together their history and make sure it's presented in a particular way. Exactly. What do you recommend?
And
Get
Tony,
them to contact you, Nadine.
Tony, we advise all people that have been injured at work, contact myself, Nadine, Tony, for legal advice as to your work injury entitlements, especially lump sum and common law entitlements.
Of course.
Where fault is an issue. And that's very important that fault is stitched up early on.
Of course. Look, this case here, if liability was an issue, you would have got an ergonomist or engineer involved, correct?
Yes.
Absolutely.
Yeah. And they would have talked about the OH&S rules, regulations. But the thing is, okay, coming back to the figure, you got $200,000 for pain and suffering, which is pretty high for someone with a knee that was pretty dodgy to start with, correct?
Absolutely. All that pre-existing.
But why didn't he get loss of income, John? What happened there?
Tony, it looks like in this case it wasn't claimed.
I think the lawyers must have thought, look, it's too hard. Is that the impression you got?
Or they only received a ticket for pain and suffering only.
And maybe they thought, we're not going to litigate this because there's so much in the history. There's some inconsistencies, and they figured, let's take 200 and play it safe. He might be still on payments. We don't know. Yeah. And at least it leaves the door open if he cannot work, correct?
Exactly, because he'll be on weekly payments till 67 years of age.
Now, look, unfortunately, we got to the end of the show. Is there anything else you'd like to add, Nadine, before we go?
Well, no, but other than hearing these stories or these cases really with such significant damages gives clients or plaintiffs like this a lot of hope that even with the pre-existing injuries, it doesn't matter, there's always an outcome for you.
Tony, we say to all people that have been injured at work, seek legal advice earlier rather than later. There's no use in seeing you 2 or 3 years after the event. And
I'll add a bit more to that. I'd say see someone with a bit of seniority that knows that's been there and done that.
Exactly.
Absolutely.
Because a lot of the young ones will not be able to get through this.
No.
It's too much of a hoop, don't you think?
It's complicated.
Viewers, we've come to the end of the show. I suggest you go to our social media pages, Facebook, LinkedIn, go to our website. Stay tuned for future episodes, and always remember to stay safe.
Don't say